It's only because he was
Is he here now?
he's in the holdover. Yes, Judge.
Have you explained this to him?
So I explained it last time, Your Honor. I tried calling the holdover today because we were under the understanding that he had signed a waiver aside from that one. But if he can step out so he can understand what's going, because I know last time he was.
Please. Do you know the name? Okay. Morning, Mr. Groves.
Morning.
I'm bringing you out just to give you an update of what's going on with your case. You were wanted out of the state of Ohio for a probation violation for I'm assuming that's weapons under disability.
Yes, I'm not familiar with the charge. I don't know what the Texas equivalent is.
The thing is this, Mr. Groves, is that when you sign for probation, no matter where you are, you need to read the fine print. Many times when you sign, you waive extradition by virtue of signing the agreement by saying, hey, if I ever take off, I will refuse to fight extradition. And that's what's happening now. So even if I wanted to give you a bond so you could go turn yourself into Ohio, I can't because you have already waived by virtue of signing for the probation. You understand? So that means that we give the demanding jurisdiction, which is Ohio, here 30 days to come get you. Okay?
This moment right here is a classic extradition wake-up call. The judge is basically saying, look, you signed away your right to fight being transported, so now Ohio gets first dibs. It's a real reminder of how powerful probation paperwork can be. Most people don't even realize what they've agreed to. What would you do if another state suddenly had 30 days to come pick you up? Let me know in the comments.
Okay? Thank you, Judge. All right. Thanks.
Thank you, Your Honor. May be excused.
Thanks, Ms. Morgan. Good morning, Ms. Hines.
Good morning.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Thank you, Your Honor. Sorry, I'm having trouble loading it. Okay, here we go. On April 23rd, 2025, in Harris County, Texas, law enforcement officers were dispatched to a suicide. Upon arrival, law enforcement officers found the defendant in the driver's seat of a U-Haul truck, slumped over the steering wheel. The law enforcement officer observed bloodshot eyes, slurred speech, and unbalance from the defendant. The passenger, the co-defendant, was detained and a crack pipe fell out of the co-defendant's pocket. The law enforcement officers found foil with narcotics.
The officer's observations are stacking up fast here. Slurred speech, drug paraphernalia, failed sobriety indicators. This is the kind of probable cause cocktail that judges rarely overlook. And notice the witness statement? That seals the timeline. Quick question for you all. Do you think officers should rely more on field tests or on blood tests when both are available?
Residue on the passenger seat of the vehicle. The defendant admitted to taking Xanax that morning, and standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 2 out of 8 on the walk and turn, a 0 out of 4 on the one-leg stand. The defendant consented to a blood test. A wheel witness stated they saw the U-Haul in motion, pull into the driveway of a house across the street, and then walked over to the U-Haul and saw the defendant in the driver's seat.
You said they did field sobriety tests? They take them to the station? What?
Yes, Your Honor. Standard field sobriety tests were conducted. 6 out of 6 on the HGN, 2 out of 8 on the walk and turn, and a 0 out of 4 on the one-legged stand.
Blood test, breath test?
It was a consensual blood test.
Any prerogative of the eyes?
No, Your Honor.
Signs I'm going to find that there's sufficient probable cause to go forward with the case. I don't know if you have a problem with drugs or alcohol. Now is the time for you to address it, because I'm telling you, if it becomes a problem while you're on bond, I'm going to address it for you. And I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
I'm ordering you not to use alcohol, illegal drugs, unprescribed controlled medication. I'm going to test you, and I'm going to test you probably within a week. Do you understand?
Yes, sir.
Do not use. If you have a problem, now is the time for you to do whatever you need to do to address it. You have the ability to hire a lawyer, ma'am.
No, I don't think so.
Okay, I need you to fill out an application for me, and I'll take a look to see whether you qualify. I will have you go, oh, you said she has a valid license?
It is eligible.
Okay, you're also not allowed to drive unless you have valid liability insurance in your name, and that is also a condition of your bond. Do you understand, ma'am?
Yes, sir.
So I'm gonna have you go to Victoria, sign a reset. Deputy Miranda is gonna give you an application. I need you to fill it out for me. When you're done, you can bring it back to us and we'll take a look. Please.
Your Honor, I'm here on a plea this morning for Jose Traconi.
Okay, are you ready?
Yes, sir.
Do you mind bringing him up? Good morning, Mr. Traconis. You speak English, right?
Yes.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 3 days in jail, credit for the 2 days that you've done. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. The next time you get pulled over, you smell like alcohol or dope, an officer's going to see this DWI. It's probably not going to go well for you. So don't give him the ammunition. Don't get into a car, even if you've had a sip. Do you understand?
I understand.
Bring up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, or give up the right to appeal. Once you plead guilty, there's no change in this. Is this what you want to do?
Yes.
How do you plead to the offense, guilty or not guilty?
Guilty.
Mr. Traconis, I want you to understand that from now on, what we're doing today, you're facing a minimum of 30 days in jail from now on if you ever pick up another DWI, not to mention a $6,000 surcharge that tax on you. And if you don't pay it every day or every $100 you owe, you sit 1 day in jail. Do you understand?
Yes, sir.
Okay. I'm going to suspend your license for 90 days. Do not drive until you get a license. Good luck to you, sir.
Your Honor, just if I may mention, I just wanted to notify the court that we will be applying for
Occupational? Okay. Sure. Okay, I understand that you're gonna have to, though, when you apply for an occupational license, you will have to do treatment. So, you know, what we normally do is we have you do a TRAS, and then whatever the TRAS says is what you end up doing, and you have to get an interlock. So I don't know whether probation is something that you want, where I don't suspend your license, or whether you just want to do this, because you're gonna undergo basically probation-esque terms regardless, if we give you an occupation. So, okay?
Yes, sir.
Okay, all right, good luck. Good morning, Mr. Is it Haran?
It's Aaron.
Heron? Ms. Heron, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Judge. This one was a 2B. On September 28th, 2024, a law enforcement officer was dispatched to a family disturbance at a residence in Harris County, Texas. The caller reported she observed the couple arguing in a truck, children crying, and heard a loud bang as if someone got struck in the head. The law enforcement officer observed the truck with one functioning headlight, matching the description that was given him regarding the truck. The law enforcement officer observed a juvenile outside of the truck with red puffy eyes. The law enforcement officer made contact with defendant 1, Ms. Heron, and defendant 2. The defendant stated there was no altercation or arguments that occurred, and that the law enforcement officer was talking to the wrong people and that they were okay. The law enforcement observed an odor of marijuana. The defendant's vehicle was sitting outside of a random residence at night, and the defendant stated the vehicle belonged to a friend.
Which defendant? Who?
I just said the defendant stated the vehicle belonged to a friend, and then there's defendant 1, which is referring to Ms. Heron for the next sentence. Ms. Heron refused to ID herself and stated she was going inside of the house. The law enforcement officer told defendant 1, Ms. Heron, to stay put until the conclusion of the domestic violence investigation. Defendant 2 exited the vehicle, stated, "No, I am not," when advised, and he was detained and pulled up his pants before getting in a bladed stance.
This is a tense moment. The judge is very clearly warning her to stop talking. And for good reason. Defendants often hurt their case more by speaking than staying silent. When the judge says, "Now's not the time," that's courtroom code for anything you say from here on out is going to wreck your defense. Ever seen someone talk themselves into worse charges? It happens more than you think.
Law enforcement officer grabbed the defendant two's right wrist. Defendant two pulled away. The law enforcement officer grabbed defendant two's shirt, telling him to stop as they fell to the ground. The defendant one, Ms. Heron, pulled the law enforcement officer's arm and pushed the law enforcement officer's chest, preventing the law enforcement officer from restraining defendant two. The law enforcement officer took out an electrical conducted weapon, told defendant one to get out of the way, Ms. Heron, and defendant one continued to refuse and push law enforcement officer's chest. Ms. Heron ID'd herself with her name and date of birth, which was confirmed with the Texas driver's license.
Ms. Heron, don't. Now's not the time. You know, I've got a bunch of DAs here. Whatever you say, they're going to use it against you. You will have the opportunity to fight your case. Just now's not the time. I'm going to find that there's sufficient probable cause to go forward with the case. Do you have the ability to hire a lawyer, ma'am?
I don't.
Okay, we can have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you, how much money you make, what kind of job you have, and then we'll take a look to see whether you qualify. I see that the co-defendant in this case has a valid warrant for his arrest. I think that there's still a warrant open for his arrest. Also on a felony warrant as well. I'm ordering you as a condition of your bond not to have any contact with the co-defendant in this case. Do you understand? If you do, I'm going to put you in jail. No more PR bonds for you. Do you understand? Okay. So Deputy Miranda is going to give you an application. I'm going to have you go to Victoria, sign and reset, and then we'll have you take your seat at the jury box while you fill it out. Okay?